Mark, after the court has rendered its decision, what comes next?
So the court is going to order one of the party's attorneys to do the initial draft of the decree or the final order. That person is generally given, 10 days to 2 weeks. They have to get it over to the other side. That lawyer is given 10 days to 2 weeks to get back with their changes, and then it kind of goes back and forth. So, the idea is so that everybody can agree on the language, and it can be, it can be implemented, and the court can sign off, and everybody's done. Unfortunately, sometimes there is something in the court's ruling that's a little vague, and so there's some arguing about that.
Yeah.
Sometimes something can be left out. Sometimes there's just a misunderstanding or different interpretation, a different belief over what is meant by certain things, okay? Let's say that the court says that the one parent will have a standard possession order. Well, did they mean just a standard possession order, or did they mean an expanded standard possession order? Did the court make a rendering at the end of the final trial? Okay, so there are a lot of different things that come into play that can affect the language of the decree, and a lot of that stuff is really, really important to make sure that you've got it right, because that's going to govern what happens, for the next however many years that you've got kids, or, with your property division and things like that. So it's real important to make sure that you spend the time, or your lawyer spends the time doing that right, okay? It is not, trial is done, you're done, whew, don't have to worry about anything. Now comes a really, really important part, the wordsmithing, to make sure that that is done right.
You want to get it done the first time because you don't want to go back unless you absolutely have to.
That's exactly right.
When you need help, call the folks at Scroggins Law Group.
We're here to help.